I am Dr. S. Silvan, Assistant Professor, PG and Research Department of Biochemistry, St.Joseph College of Arts and Science, Autonomous Cuddalore. Now I am going to present the topic Intellectual Properties of Rights. Intellectual property. Intellectual property is the product or creation of the mind. It is different from other properties in term that it intangible. Hence, it needs some different way for its protection. Next, what is the intellectual property rights? IPR is the body of law developed to protect the creative people who have disclosed their invention for the benefit of mankind. This protects their invention from being copied or imitated without their consent. The Indian Patent Act. In Indian, the grant of patent is governed by the Patent Act 1970 and Rules 1972. The patents granted under the Act are operative in the whole of India. The history, the Patent Law of 1856, the Patent and Designs Act 1911, the Patent Act 1970 and Rules 1972, the Patent Amendment Act 2005. What is patent? A patent is a grant from the government which confers on the guarantee for a limited period of time the exclusive privilege of making, selling, and using the invention for which a patent has been granted. The purpose of getting a patent to enjoy the exclusive rights over the invention. The patent is to ensure commercial returns to the inventor for the time and money spent in generating a new product. What can be patent? In order to patentable, an invention must pass four tests. The first one, the invention must fall into one of the five statutory classes. The processes are a machine, manufacture, compositions of matter, and new uses of any of the above. The second one, the invention must be useful. The third one, the invention must be novel. The fourth one, the invention must be non-obvious. Patent law and its silent features. The both product and process patent provided. The term of patent 20 years. The examination on request, both pre-grant and post-grant opposition. Fast track mechanism for disposal of appeals. Provision for protection of biodiversity and traditional knowledge. Publication of applications after 18 months with facility for yearly publication. Sustainably reduced timelines. Safeguards in the patent law. Compulsory license to ensure availability of drugs at reasonable prices. Provision to deal with public health emergency. Revocation of patent in public interest and also on security considerations. Next, what are the conditions of patent? The first one, novelty. The matter disclosed in the specification is not published in India or elsewhere before the date of filing of the patent application in India. The second one, inventive step. The invention is not obvious to a person skilled in the art in the light of the prior publication or knowledge or document. The third one, industrially applicable. The invention should possess utility so that it can be made or used in an industry. Next, what are the types of patent? The patents are majorly classified: utility patent, design patent, plant patent, and reissue patent. The first one, utility patent. In this patent may be granted to anyone who invents or discovers any new and useful process like machine and article manufactures. Second one, design patent. This patent may be granted to anyone who invents the new, original and design for article of manufacture. The third one, plant patent. This patent may be granted to anyone who invents or discovers or reduce any new verify of plant. The fourth one, reissue patent. This patent may be granted to anyone who invents and discovers the old patent in new, original and new verify of plant. The next, what are the stages of patent? The stages of patents are filing a application for patent, examination, grant of patent, opposition, time and date of patent. What are non-patentable inventions? The invention falling within section 21 of the Atomic Energy Act in 1962 are not patentable. Example, invention relating to compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium and more as notified by central government from time to time. The terms of patent. In respect of a invention, claiming process of manufacture of a substance intended to be used as food or medicine. The 5 years from the date of sealing or 7 years from the date of patent, whichever is shorter. In case of many other invention, 14 years from the date of patent. What are the reasons for expiry of a patent? A patent can expire in the following ways. The patent has lived its full term. The patentee has failed to pay the renewal fee. The validity of the patent has been successfully challenged by an opponent by filing an opposition either with the patent office or with the court. As soon as the patent expired, it passed to the general public domain and now anybody can use it without the permission of the original inventor. The stages filling to grant of patent. The filling of application and then publication of application and then request for examination and then examination of issue of FER and then the grant of patent. and the grant of patent after the decision of controller and then appellate board and then revocation and the amendment.